Can a bank foreclose on a house in probate? Hey guys, I'm Brad with sellhousefastgeorgia.com, and I'm here with my business partner and attorney, Josh Rand.
Hello.
And today we're talking about a house in probate or estate property, and the property's in foreclosure. So obviously there's different stages to this, right? You may have already filed for probate and you're waiting to get your probate letters, or maybe you haven't filed probate yet. So why don't you elaborate on those two situations and what kind of might occur there?
The answer is, can a bank foreclose on a property that's in probate? And the answer is yes. So you have to go through the same steps potentially that we've talked about before, although it does add a little bit of complexity because, as Brad mentioned, sometimes you haven't even gotten to the point of opening up a probate estate. And in those situations, you have to be careful because the banks won't even talk to an heir unless they've been authorized or an estate's been opened that puts somebody in place who's authorized to talk to the bank. And that can be a real obstacle to be able to get a house closed prior to that foreclosure deadline.
Yeah, and we have seen in some instances with some estates that I've dealt with where they can petition the court for temporary letters of administration to maybe be able to talk to the bank, to maybe be able to open a safe deposit box that might have the documents in there. Maybe the will is in the safe deposit box of the bank and the bank won't even let you touch it. So you can petition the court to give you temporary letters of administration, but in most cases, those temporary letters do not give you the authority to sell a property. You still have to have your letters, but that is a stopgap measure to be able to talk to the bank in the first place.
Yeah.
So being able to talk to them is the hardest part, really.
So just don't be fooled. If your property is in a probate situation, don't fail to act because you think that the bank can't foreclose. They can.
They can, yeah, because there's a debt owed to them and they have the power to basically sell, especially in the state of Georgia, it's what's called a deed under power, right? Mm-hmm. And when you take out a mortgage, part of your documents, you give that bank the power that in the event that it's in default, they can sell that property.
That's right.
Because we're a non-judicial foreclosure state, a judge doesn't have to sign off on that.
Correct.
So,
yep.
Yeah. So if you have a property that's in foreclosure, you're in probate, do not hesitate. Make sure you start making phone calls right away. If you're interested in speaking with us and maybe discussing your specific situation, we are experts in the world of real estate and probate and foreclosures, all of the above. We'd be happy to discuss your specific situation and figure out, give you some answers there. If you're interested in selling a property, maybe you're already done with probate, you're ready to sell this property, you want to sell it before the foreclosure auction happens, we pay cash, we buy as is, we close quickly. Or if you've got a little bit of time and you want to try to get top dollar out of that property, I'm actually a licensed real estate agent in the state of Georgia. I can help you out with that as well. And again, if you're just looking for answers to your situation, please don't hesitate to reach out to us. There is a form below on the website. You can fill out that form. It'll send an email to a member on our team, and a member of our team will call you ASAP, and hopefully we can help you get you some answers. So thanks for checking out this video. I'm Brad, here with Josh. Hope you have a great day.